You can't bring him back. No matter how much we go through court, you can't ever bring Samuel back.
After I got as much washed out of my hair and off my face as I could.
Cora's condition as gruesome, with blood covering her face and body.
I'm not a gang member, never have been, never will be.
Alicia Cocken, the woman convicted of shooting and injuring an officer from the Oconto Falls Police Department, was sentenced to 16 years in prison. The sentencing relates to a 2021 incident where Cocken managed to grab Officer Nicole Blaskowski's gun during a physical altercation and shot her. At the hearing, Blaskowski delivered a statement expressing that her greatest concern throughout the ordeal was for her children.
The day before you entered my life, I took my kids to spend the day at Neshota Beach. This was the mother they had known all their life, the one who was there for everything. This is the mother they came home to. These photos were taken right after I had gotten home, after I cleaned up the best I could before they got there. After I got as much washed out of my hair and off my face as I could.
Alongside her 16-year prison sentence, Cocken will also serve 12 years of extended supervision. Those were the judge's words before sentencing Thomas Humphrey of Goffstown to 40 years to life in prison for the murder of his mother, Linda Tufts. The gruesome crime occurred after an argument over the volume of his video games, during which Humphrey stabbed his mother.
You tore a family apart, the grief, the anger, the pain that just continues on. You took one of our matriarchs of the family, and it's completely unforgivable.
When police arrived at the house, they discovered a fire and found Humphrey at the bottom of the basement stairs, holding a knife and suffering from self-inflicted wounds. He was subsequently charged with second-degree murder and arson, to which he pleaded guilty to both charges.
The brutality of this crime simply makes it too dangerous not to impose a very lengthy state prison sentence.
Humphrey was also sentenced for arson and will serve an additional 5 to 10 years. Both sentences will be served consecutively. Erica Carruthers took the stand during the sentencing of 20-year-old Gavin Kassab. Kassab, along with the driver at the time, faces charges of fleeing and manslaughter following a crash that resulted in the tragic death of Erica's daughter, Piper. The incident also left Erica injured and caused severe harm to their other daughter, Cora Carruthers. Kassab has pleaded no contest to the charges.
One officer who responded to the crash, seen in later hearings, described Cora's condition as gruesome, with blood covering her face and body and the street.
Kassab and the driver are accused of running a red light at Maple and Decker in Walled Lake, initiating a police chase that ended in a crash, tragically killing Piper Carruthers.
After the crash happened, Gavin ran from the scene, again showing no compassion for the shattered lives and for the devastation that was caused from his action.
At the time of the crash, Kassab was already out on bond for a separate crime. He took the stand and expressed that he has since changed his ways.
I apologize. First and foremost, I apologize to the Carruthers family, all the victims in the community, for their terrible loss and the harm I have caused.
Judge Victoria Valentine sentenced Kassab to 8 to 15 years on 3 counts and 5 to 10 years on the 4th count.
The harm that you've done to the community is unfathomable. The amount of opportunities that you had to retreat and to tell the driver to retreat, you never did.
The juvenile driver is still awaiting judgment, while Kassab is set to appear in court on July 18th for his other pending criminal charges. In a courtroom filled with supporters of Brian Keeley and family members of Samuel Sterling, the former Michigan State Police Detective Sergeant was formally arraigned on Wednesday morning, facing murder charges related to Sterling's death.
At this time, the court is going to call People of the State of Michigan versus Brian William Keeley.
Former Michigan State Police Detective Sergeant Brian Keeley stood before a Kentwood District Court judge as his supporters filled his side of the gallery, all dressed in matching blue shirts to show their support.
Mr. Keeley, in this matter, the people are alleging you committed the following offenses.
Keeley listened as Judge Sturkenberg outlined the charges against him: second-degree murder and involuntary manslaughter in the death of Samuel Sterling. Both charges are felonies, carrying a maximum sentence of life in prison.
Do you understand those charges?
I do.
Keeley entered a plea of not guilty to both charges. His supporters believe the accusations are unjust.
I just think it's too easy to blame the police officer for doing his job. I say in this whole deal, when I first heard it, this should be a dismissed case.
For this trooper to face such charges, I think is just so heartbreaking for me.
Attorney Curtis, would you like to make argument for bond?
Samuel Sterling's family members were seated on the opposite side of the courtroom.
I miss my son a whole lot. That was my baby, so I miss him a whole lot. You can't bring him back. No matter how much we go through court, you can't ever bring Samuel back.
The judge set a $250,000 personal recognizance bond for Keeley, meaning he won't have to pay any money up front to be released from police custody. Supporters of Samuel Sterling believe the low bond sends the wrong message and have voiced their concerns about its appropriateness.
He's been charged with second-degree murder, and he was patted on the wrist out of here on a personal recognizance bond. Is a message to law enforcement that our lives don't matter.
I'm disappointed. Very disappointed. I'm surprised. I'm just lost for words.
It's just the first step to get justice for my son.
Keeley's next hearing, a probable cause session, is scheduled. Supporters of Samuel Sterling have announced plans to hold a rally on the steps of the state capitol. Donald Santini, a fugitive on the run for nearly 40 years, wiped away tears during a court hearing. After evading law enforcement for decades, he was finally apprehended and returned to Hillsborough County to face a murder charge. During the hearing, Santini requested to be released on bond, but prosecutors argued that he should remain in jail until his trial. After years of eluding capture, Santini's luck had finally run out, ending his decades-long evasion.
He is not entitled to any bond based on what came out of his own mouth.
Santini is seeking release from jail and has asked the judge for a bond. Prosecutors, however, insist he should remain in custody until his trial, arguing that he is a serious flight risk. They highlight that Santini himself admitted to investigators that he skipped bail back in 1983 on an armed robbery charge in Texas. Just 1 year later, prosecutors allege that he committed a murder of Wood in Tampa, a crime that has kept him evading capture for nearly 4 decades.
You have from his very own mouth that he knows he's been on the lam for 39 years and that he purposely has been using fake IDs so that he could avoid law enforcement.
Santini stands accused of murdering Cynthia Ruth Wood in 1984. Her body was found in a ditch just days after she was reported missing, and investigators determined she had been strangled to death. Authorities claim that Santini's fingerprints were found on her body. Shortly after the crime, he fled town and remained on the run for decades, using numerous aliases to conceal his identity. It wasn't until police tracked him down in San Diego that he was arrested and brought back to Florida. He's now being held at the Hillsborough County Jail, though he could be released if his attorney's arguments persuade the judge.
They can't even prove to you that he failed to appear. They can't give you a warrant for his arrest.
After reviewing all the evidence, the judge delivered the final decision.
Being on the run, my words, for almost 40 years is a consciousness of guilt. You knew you were running from something. You're the definition of flight risk. There is nothing I can do to preserve the safety of this community if I were to let you go.
Santini was denied bond and will remain behind bars until his trial date. The case for former HPD officer Gerald Goins will begin tomorrow. Goins was found guilty on felony murder charges for fabricating evidence to obtain a false drug warrant. The warrant led to a 2019 raid that ended in a fatal shootout, resulting in the deaths of a couple inside their home. The jury reached a swift verdict, but due to the judge's gag order, no one directly involved in the case can comment until after the punishment phase, which begins tomorrow. If convicted, Goins faces the possibility of spending the rest of his life in prison. It took the jury 7.5 hours to convict former HPD narcotics officer Gerald Goins for the 2019 murders of Dennis Tuttle and Rogina Nicholas. Although Goins never fired a shot during the incident, he admitted to lying to obtain a no-knock warrant for the couple's home. The warrant led to a violent confrontation between the Tuttle family and Houston police, resulting in the deaths of Tuttle, Nicholas, and their dog. Several officers were also injured in the exchange of gunfire.
I'm wearing purple because this is Regina Nicholas' favorite color, and it was good luck.
Hai Bui founded We the People Organize, a group he established 5 years ago in response to the failed Harding Street raid.
To be honest with you, I didn't think this day would happen.
Bui attended every day of Goins' 2.5-week murder trial, diligently taking notes to document what he considers a pivotal moment in Houston's history.
What happened to Tuttles could happen to anyone in Houston. You know, what Goins did was just totally wrong.
Bui says his efforts will continue even after Goins receives his sentence.
It's a systemic problem. It's not one apple.
Whenever there's a guilty verdict for law enforcement, we tend to say one bad apple. We've had one bad apple too many times.
Harris County Precinct 1 Commissioner Rodney Ellis stated that the verdict against Goins highlights the urgent need to thoroughly examine law enforcement accountability and the policies and procedures that govern officers' use of force.
A review to come up with a model use of force policy. And then it's up to each department to adopt it.
Although there are no use of force policies at the county level, the city did implement one following the Harding Street raid. HPD officers are still permitted to execute no-knock warrants, but now each warrant requires personal approval from the police chief. The sentencing phase for Goins could be extensive, as it may include previously unheard allegations of misconduct that were not presented to the jury during the trial. A new judge has been assigned to preside over the trial of 3 former San Antonio police officers involved in the shooting death of Melissa Perez last year. The defense and prosecution raised concerns about Judge Stephanie Boyd overseeing the case. In response, Administrative Judge Sid Harrell decided to appoint a different judge for this major trial.
I cannot see where it would be fair or efficient to allow this case to go forward with Judge Boyd.
Judge Harley granted the defense's request to remove Judge Stephanie Boyd from the case involving 3 former San Antonio police officers, Alfred Flores, Nathaniel Villalobos, and Eliezer Alejandro, accused of fatally shooting Melissa Perez inside her apartment complex. Villalobos' attorney, Jason Goss, argued that Judge Boyd was biased against him, noting her desire to proceed with the trial this month, despite defense attorneys requesting more time to review the evidence and Goss being on paternity leave.
It puts me in a position of having to advise my client, either you get me or you get your best defense. And it's an untenable position to put me in as an attorney because I have to take care of my child.
The defense also highlighted the judge's social media, which streamed her court proceedings. They argued that videos from the channel have been edited and repurposed to mock or discredit clients and attorneys, including Jason Goss. As Goss was testifying about these concerns, Judge Boyd entered the courtroom.
Judge, I apologize. Could you step out because I don't want them to try to call you?
Sure. What did you think about Judge Boyd walking in during the middle of the hearing?
I think it speaks for itself.
The defense requested that the judge compel lead prosecutor Jeff Mulliner to testify.
With the elected judge of the 187th, it is one more issue for me to have some very significant concerns about the possibility that this works or operates along with other possible factors to make a conviction should there be one.
Judge Harrell did not specify who the new judge will be or when they will be appointed to the case. New developments in a deadly hit-and-run case in South Jersey, where a mother of 3 tragically lost her life. In court, the suspect appeared, and it was revealed that the incident may have been linked to a love triangle. Shortly after 30-year-old A.G. Williams was brought into court, new details emerged indicating this was no ordinary hit-and-run. It was revealed that Williams and the victim, Carla Mahan, were acquainted and connected through a shared romantic partner. Williams' defense lawyer referenced this relationship during her initial court appearance.
There's bad between these two parties, and of course it involves a man.
That man was present among the spectators in the courtroom for the hearing.
It involves my client's children's father, and a relationship with this woman.
Then, the prosecutor cited testimony from an eyewitness.
When he observed a physical altercation between 2 females.
When 41-year-old Carla Mahan, a mother of 3, was struck and killed, prosecutors detailed the moments leading up to the incident. The defendant, A.G. Williams, a mother of 2, had just picked up her children in her Dodge Durango. The children were inside the vehicle when Williams allegedly ran over Carla intentionally. though the defense argued it was accidental. According to prosecutors, after the two women got into a physical altercation in Camden, an eyewitness stated that Carla broke free and began to walk away. However, Williams did not simply drive off, but instead, the witness claimed, escalated the situation further.
Your Honor, this witness then indicated approximately a couple seconds later, he heard another female who he knew as Diamond yell, "Damn, she ran her over."
My client was essentially fleeing an attack. And then at some point, when my client was back in the car, words continued to be exchanged between the parties. At some point, the victim pulled a switchblade, attempted to get into the car from the passenger side. My client panicked, backed up, went forward, and in that maneuvering, the victim unfortunately was run over.
The prosecutor concluded the case by recounting the final moments of Carla's life.
Someone who is out on the street getting beat up, then out on a grassy lot trying to get away, on their feet, being run over by an SUV.
The judge decided to uphold the first-degree murder charge and ordered Williams to remain in jail until her next hearing, scheduled for a week before Christmas. A Kentucky man accused by police of murdering his entire family and another individual, then falsely claiming he was the only person to escape a kidnapping, appeared in court today. Observers in the courtroom expressed doubts about whether he was truly capable of committing such violent acts.
Good afternoon. The court calls the case of Commonwealth versus Ryan Champion.
Ryan Champion appeared in court in shackles after being formally charged by investigators with capital murder and kidnapping.
He acted erratically the entire time.
This was Champion, describing how he was the sole survivor of a brutal attack allegedly carried out by 22-year-old Vito Riservato, whom investigators say had only met the family a few days prior.
Let me ask you, are you able to hire your own attorney?
Possibly.
Kentucky State Police now claim that Ryan Champion is responsible for the deaths of his father, Lindsay Champion, his mother, Joy Champion, his sister, Emily Champion, and 22-year-old Vito Riservato. However, his friend Ann Plotkin remains adamant and refuses to believe the accusations.
I don't understand it. I really don't, because I know Ryan and know. There is no way.
Ryan Champion's arraignment comes just a day after his family was laid to rest, leaving the community struggling with the shock and trying to comprehend how something so horrific could happen. If found guilty, Champion could face the death penalty. A preliminary hearing is scheduled where additional details about the case may be revealed. Harris County Sheriff's Deputy Sandeep Dhaliwal tragically lost his life in the line of duty during a traffic stop in northwest Harris County. Now, the man accused of his murder, Robert Solis, is on trial. In an unusual twist, Solis chooses to represent himself in court and delivers his own opening statement.
I stand before you an innocent man.
Over 3 years after his initial arrest and charge with capital murder for the fatal shooting of Harris County Sheriff's Deputy Sandeep Dhaliwal during a routine traffic stop, Robert Solis is now on trial. In an unusual move, Solis has chosen to represent himself in court. During his opening statement, he addressed the jury, asserting his innocence in the killing of Deputy Dhaliwal.
I believe that I will be able to show that I had no intentions.
To support their case against Solis, prosecutors presented some of the most compelling and emotionally charged evidence yet. They showed the jury body cam footage from Deputy Dhaliwal, capturing the moment Robert Solis leaped out of his car, approached Dhaliwal's patrol unit, ordered him to raise his hands, and then shot him at point-blank range. The graphic video left members of the jury and Dhaliwal's family visibly moved, with many seen wiping away tears. Despite this powerful evidence, Solis responded by asking the judge for a summary judgment, arguing that the state had not provided a strong enough case and requesting to be acquitted.
I stand before you an innocent man until y'all go back there and deliberate and determine whether or not the state has met its burden on whether I intentionally and knowingly, with a conscious objective, shot this deputy.
Robert Solis has already found himself in multiple heated exchanges with the judge overseeing the case. At the end of testimony, he even requested that the judge recuse himself and step down from the trial altogether. In 2012, Gail Spencer, a 58-year-old legal secretary in Macon, Georgia, became the target of a deadly scheme. Known for her dedication and trustworthiness, Gail handled financial transactions at Calder Pinkston and Associates. Her access to wire transfer systems made her an essential part of a plan devised by her colleague, Tracy Michelle Jones, to steal $1.4 million. To carry out the crime, Jones enlisted her boyfriend, Michael Brett Kelly, his half-sister, Courtney Kelly, and an accomplice, Keith Anthony Dozier.
Now, why couldn't Gail get work for your plan?
Because Gail was the office manager, and she usually did the transactions, the wires, and she would have handled that. There was a big account that day, and she would have handled the big account.
So you knew that day there was going to be a large amount of money?
Yes, sir.
Is it fair to say in order for your plan to work, she couldn't be there?
Yes, sir.
Because she would have been doing the wires, not you?
Yes, sir.
The conspirators planned to eliminate Gail's ability to interfere with their embezzlement scheme. To this end, on the evening before the crime, they gathered supplies, including ski masks and gloves, to conceal their identities. Each person's role was carefully orchestrated. Tracy Jones would gain access to Gail's home. Brett Kelly and Keith Dozier would ensure Gail was incapacitated, and Courtney Kelly would receive and launder the stolen money. The plan hinged on removing Gail from the equation so the group could access the firm's funds without resistance.
Now, you talked about that the night before they bought ski masks and things like that.
Yes, sir.
Were they wearing those ski masks when they came in?
Yes, sir.
Were they wearing gloves?
They had ski masks, jackets on, gloves.
On October 5th, 2012, Jones visited Gail's home, pretending to need help. Gail, ever accommodating, allowed Jones inside to use the restroom and borrow her phone. Once inside, Jones signaled to Brett Kelly and Dozier, who were waiting outside.
Once you got to Gail's house, what did you do?
I knocked on the door, and she didn't come to the door, so I went back to the car. And Brett told me to drive around to the other way, because when we pulled to the side of the road. And when I went back to the car, he told me to pull around to the back of the house. And I pulled in the driveway, and I pulled back out and pulled down in the cul-de-sac in the park. And I went back to the door and knocked, and she came to the door. And when she came to the door, I asked her if I could use the restroom, and I needed something to drink, and if I could use the phone. And I used the restroom, and when I came out of the restroom, she fixed me something to drink and gave me her phone, and she said, I gotta get ready. So she went in her bedroom, and I was in the kitchen drinking the drink, and that's when Dozier and Brett came in.
So your role was to get the door open?
Yes. And I texted Brett when I was in the restroom. I told him I was in the house. And Brett told me to close the blinds. And they walked in the hall. When they walked in the hall to go into her bedroom, they shut the door. And I shut the blinds, and I ran out the door.
Did you take anything of Gail's?
I took her phone.
Her cell phone?
I had her cell phone in my hand, and I took it with me.
What did you do with that cell phone? You send any messages from her?
I called her a message and told him that she would be at work that day.
Okay, but that's obviously from Gail's cell phone.
Yes, sir.
So it looks like Gail was sending a message.
Yes, sir.
Wearing ski masks and gloves, they entered Gail's home, confining her to her bedroom. In a horrific turn, Brett Kelly sexually assaulted Gail before suffocating her with a plastic bag. Their actions ensured she could not interfere with the theft.
Between the 2 days, approximately how much money did you transfer out of Mr. Pinkston's account? How much money did you and your co-defendants take?
$1.4 million.
And Mr. Dozier knew about this plan?
Yes, sir.
He was a willing participant in this plan?
Yes, sir.
With Gail incapacitated, the conspirators used her credentials to access the firm's accounts. Over the next 2 days, they transferred $1.4 million into accounts controlled by the group.
Asking about the transfers?
Yes, Brett sent me a message and said that he was over there and he had to take him to the ATM to show him the money was not showing up yet.
So from the 4th through up until the 10th, the defendant knew of this plan. And he was involved.
Yes, sir. I transferred the money from Mr. Carter's account into Courtney Kelly's account.
Is that just because it was easier to do into one account?
Yes.
But is it fair to say that the plan was to divide the money afterwards?
Yes, and actually, Dozier was getting more. He was getting $300,000 out of $800,000, so he was getting more than we were getting.
Okay. So he's actually getting a bigger share than everybody else.
That's right, because there wasn't supposed to be any more money taken out.
Okay. So
before Courtney took off.
All right. So he's actually getting almost 50% of the proceeds of this theft.
Yes.
And he knew about this theft was going to occur before it occurred.
Yes.
All right. At any time afterwards.
To avoid suspicion, Jones sent texts from Gail's phone, making it seem like Gail was at work as usual. The group believed their plan had succeeded, but Gail's absence from her neighborhood and workplace quickly raised alarms. Neighbors, noticing something was wrong, contacted authorities, who discovered Gail's body in her home.
We're on in her house, all the lights were on in the house, and she just didn't leave any, especially all the lights on. She just didn't leave the lights on.
And had she ever left Camel outside?
Yes, she left Camel outside. He was outside. He started barking at him when we come up.
But had she ever left him outside before?
No, sir.
So that was unusual.
Very.
Did you try and check on Gail?
Yes.
Okay. And how'd you check on her?
Went through a gate and knocked on the door. And I couldn't get her to the door.
Did you hear anything did you hear any noise coming from inside the house?
Yes, Lola, dog, her dog.
Her dog?
Yeah.
And what was Lola doing?
She just whimpering and she would come to the door, I could hear her in there.
Okay. And you may have already answered this, but were the lights on in her house?
Yes.
Was there anything strange about the windows?
Well, I knocked on the bedroom.
Okay.
Wake her up Saturday, you got to just do all that, but everything wasn't right. And I told the wife to go get the key.
All right.
So I got the key from the wife and went unlocked the bottom lock, but the top deadbolt was locked, and there was a key. She broke off into it. And as long as she could lock it from the inside, I was good, but I couldn't get the deadbolt off.
Okay.
So I tried to reach to the doggy door, and I noticed it was ice, cold in there, real cold in there.
Did you check to see if the car was there?
Yes.
Okay.
I walked around the front of the house and looked up in the window, and the car was gone.
All right. What did you do after that?
Told my wife I was going to run up to where she worked.
The investigation that followed uncovered a trail of evidence, including text messages, bank records, and witness statements. These pointed directly to Jones, Brett Kelly, Dozier, and Courtney Kelly as the perpetrators. Their roles were clear. Jones had orchestrated the scheme, Brett Kelly had committed the murder, and Dozier and Courtney had assisted in the execution and laundering of the stolen funds.
We're just grateful to be able to get justice for Gail Spencer, her family, and the community on 3 out of the 4 defendants. Had the attorney not gotten sick earlier this year, we would have wrapped these folks up about a month ago.
Following the crime, all 4 conspirators were apprehended. Tracy Jones, Brett Kelly, and Courtney Kelly pleaded guilty to felony murder and other charges. Jones and Brett Kelly received life sentences without the possibility of parole, while Courtney Kelly was sentenced to life in prison with the possibility of parole.
I was in the kitchen drinking the drink, and that's when Dozier and Brett came in.
So your role was to get the door open?
Yes, and I texted Brett when I was in the restroom and I told him I was in the house.
Dozier, who pleaded not guilty, was convicted in 2015 of malice murder, aggravated assault, and theft by taking. He said that he was afraid Kelly would kill him if he tried to stop. He also claimed that he tried to talk Kelly out of going ahead with the plan. He was sentenced to life without parole plus 20 years. In June 2019, Dozier appealed his conviction, but the Supreme Court of Georgia upheld the original sentence. Those were Kira Russ's final words to her family as she was escorted away to begin her life sentence in prison. Kira Russ has been sentenced to life in prison for her role in the 2016 shooting outside a Fort Myers nightclub, an incident that claimed the lives of Sean Archills and Stephen Strotter. Russ maintained her innocence during her sentencing and made a plea in court. However, the judge handed down a life sentence, along with an additional 15 years in prison.
I will sentence you to life in prison on that count.
This is the reality Kiera Russ must now face. She becomes the first individual to go to trial and receive a sentence for the 2016 nightclub shooting. Although she was not the one who pulled the trigger and killed the 2 teenagers, she was present that night in court. Russ continued to insist on her innocence.
I'm not a gang member, never have been, never will be. And I wasn't anyone's lookout or spotter. I specifically went there because I was invited to perform.
A jury found Russ guilty of her involvement in the murders of Sean Archilles and Stephen Strotter. Emotions ran high in the courtroom after Russ declared her innocence once again.
I still have hope. So with that being said, I'm just going to continue to fight for my innocence and real justice. To the families of Stephon and Sean, my heart goes out to you all, and I'm sorry you all have to go through this.
Before Russ was handcuffed, she shared a few final words with her family.
I love y'all. I'm okay. I'm good. God got me. Love y'all.
State Attorney Amira Fox expressed her hope that Russ's sentence would serve as a strong message to anyone considering involvement in criminal activity.
You do not have to be the one to pull the trigger, as we saw today, to end up going to prison for a very long time. In fact, for life.
Russ's attorney announced that he plans to file an appeal for her case. Meanwhile, the state attorney's office continues to prepare for 4 additional pending trials involving other suspects in the case. In Delta County Circuit Court, 30-year-old Michaela Maupin from Gladstone pled guilty to second-degree child abuse and involuntary manslaughter in the death of her daughter, Melina. Maupin was arrested after Melina drowned in the family's bathtub, where she had reportedly been left unsupervised with the water running for 20 minutes. Maupin is currently held at the Delta County Jail on a $1 million cash bond. Facing up to 15 years in prison for the 2 felonies, she is scheduled to be sentenced on August 27th at the Delta County Courthouse. On July 7, 2018, in Akron, Ohio, a horrifying act of violence unfolded when 2 brothers, Orlando Teus and Donyea Teus, took the lives of Bon Rasavong and Robert McCall. The tragic incident occurred in a parking lot, leaving the local community devastated and in mourning. The brothers confronted their victims in the parking area, where a dispute escalated into a fatal shooting. Both Rasavong and McCall tragically died at the scene from their injuries. Witnesses described the attack as cold-blooded and entirely unprovoked, leaving the victims no opportunity to protect themselves. Authorities swiftly arrested the Teus brothers, charging them with multiple crimes, including first-degree murder. During questioning by law enforcement, one of the brothers displayed notably suspicious behavior. He repeatedly dodged questions and avoided giving straightforward answers about the events surrounding the killings. This evasive demeanor raised doubts about his credibility and willingness to cooperate. Investigators highlighted the stark contrast between his lack of openness and the severity of the crime, which demanded serious accountability.
We're gonna set this polygraph up for you. This is some bullshit. What do I get from this? When I pass this polygraph test, what do I get? My name free. Well, tell the family. You know what I'm saying? My name free. Well, here's the deal. Yeah. You pass to tell the family, say, hey, he passed it. He had nothing to do with it. You know what I'm saying?
Don't tell the family, man. Don't tell the family.
Your name is, look, bro, look.
Don't tell the family.
They know, your name already know about you already. You said, not from us. You know how the streets are. You know how the streets are. So we said, look, he had nothing to do with it. Period. So y'all need to move on. You know what I'm saying? So
can we take this body back? They knew your name before we did.
Yeah.
Of course, because they did. Yeah, Taylor in my baby mom, man. Let's get back to one thing. What time did you get home Friday?
I just said, I don't know. I said, check the cameras. I pulled up with my white boy Project Matt. The car started out on its own wheel, but my white boy Project Matt pulled up on us.
If you had to guess. I don't know, man. I said the car went down at 7.
No, I never said no time. What time the car went down?
Around 7.
No, I never said no time. Check the cameras. I never said no time, bro. Never said no time. I said, I don't know. The car started out on Wheelbiff, right there towards Archwood. Towards Manchester. The car started out. We put it in the parking lot.
You have a phone that ran? Was it light out?
Go ahead, man. I'm sorry.
Was it light out or dark out?
It was still light outside.
Okay, so it was probably before 7, man.
Could have been.
Because it's dark right around 7.
It wasn't dark yet.
So when you got
matter of fact, let me tell her, because my white boy, he said he had to go pick up his kids, so it had to be about 5 o'clock when I got to the house.
You got to your house.
When he pulled, he had to go pick his kids up. See, I don't like. I feel like it's trick questions. I'm straight up, man. I don't got nothing to do with this. Take that polygraph test. I can clear my name, man.
And you never left after that?
I ain't go nowhere, but I stayed at the house.
Okay.
I just told you I would.
So Saturday.
I cannot go somewhere with no car, man.
Doesn't your brother have a car?
Call him that. He ain't got no car.
I asked you.
Just give me my body back. So let me ask you something else. You called the police on Saturday morning. Your girl called you. Tell me why.
Who called me? I woke up. I had missed call. I don't even with Joseph for real, man. Joseph, you know what I'm saying? He just lied on my name. So boom, I wake up. I got missed calls from no missed calls from Taylor though.
Right.
Missed calls from Francesca. I just called CSB on my bag monster. I'm like, all right, she just on some retaliation shit. Around and answer the call. Bitch, you calling like when you called. When you was there, she was calling. Boom. What you calling my phone for? I don't with you, but I'm real, and who was murdered and robbed this one? I said, what? And yeah, remember 4 months ago you said you was gonna rob who? Yeah, everybody, Taylor's telling everybody you did it.
So, what time was that when you called you about the thing?
It was right before I called you guys.
Okay.
I called y'all right away.
Okay.
Right away.
Okay.
Did you call Francesca that night? Oh my God. I don't, that's my kid's mother. I don't know. Probably to talk to my kids, probably. I call all the time to see if I can speak to my kids. Friday night? I don't know, sir. I don't know her. Did you call her? I don't with Taylor. No, check her phone records, man. You asking me y'all can just go check the records for it, man. Why are you trying to catch me up in the lie? I don't know. I use my phone all the time. When I call my kids' mother, can I speak to my kids? I'm just they not around me. Here you go, or here you go right here. That's all, brother. I don't call Taylor. I don't call Joe. I don't call none of them, man. I don't I'm hurting people, man. And I'm off. My name is in this. My life is at jeopardy, and all the motherfuckers seem to care about this phone, what time. Man, come on, man. I don't have nothing to do with this. Take my cameras over there. Give me the lie detector test. Let me clear my name, man. So y'all can go tell his family. Now, he ain't got nothing to do with it.
Wouldn't you want that?
Man, I don't give a fuck. I don't give a fuck. Man. Alright, I don't care, man. My life been miserable anyway, man. If I get murdered or something I ain't got nothing to do with it, it's God's will, bro. Okay. I done made it through a lot, bro. I ain't did nothing to this man. I'm gonna look in your eyes and I'm gonna tell you that. I ain't did nothing to this man. I ain't had no intentions on killing this man, intentions on robbing this man. Never in my life.
Okay.
Don't even know this man.
Alright, man.
Don't even know.
Okay.
But you know me better once.
You know me. I don't know you. I met him once through them. They know him. They was having that's knowing the motherfucker. Me just seeing him. Hey, what's up? I said $5 and never heard. Not me knowing that man. He ain't gonna never open the door for me. He don't know me. If I knock at his door for myself, man, he wouldn't open the door for me, man. I don't know that, man. Honest to God, true. Can we get this test out the way? I'm ready for this test. How accurate is this test, man? Because I don't want to go down for nothing I ain't do. Very accurate. Okay. I don't want to go down for I ain't do, man. I'm gonna one test. No, it's very accurate, man. We never put anybody through. All the years you've been doing, that's never happened. Okay, so you straight.
During the trial, the prosecutor highlighted the gravity of the crime, describing it as a calculated and disgusting act. They vividly outlined the devastating impact the murders had, not just on the families of the victims, but on the entire community. The prosecutor emphasized the tragic and needless loss of life, shedding light on the deep emotional wounds suffered by the victims' families.
All right, go ahead, Mr. Cornell, on behalf of the state.
Thank you, Your Honor. First of all, in regards to the counts of the indictment in which the defendants have been convicted, the state would concede as it pertains to count 1 and 2, which are aggravated murder and murder upon Rasselman, that those counts would be murdered for purposes of sentencing, and the state would elect to have both defendants sentenced under count 1, the aggravated murder charge. As it pertains to count 3 and 4, those are likewise aggravated murder and murder convictions in the death and homicide of Robert McCall. The state would concede that those merge for purposes of sentencing, and the state would elect to have both defendants sentenced pursuant to count 3 in the aggravated murder conviction. As far as the state's position as to what the appropriate sentence is for Dylann Roof and Orlando Tyus, there really is not too much more to say. The court had the opportunity to hear evidence for 2 weeks. And really, Your Honor, there are not words to articulate how sad, as well as evil, this entire case is. It's sad for the Rasselman family, sad for the McCall family to lose a loved one for absolutely no reason for the defendants. They were willing to kill anybody and everybody that day. The one word, when we talk about the acts that were committed, the best word I could come up with is monstrous. And because of their monstrous acts, on behalf of the family, the state is requesting that both defendants receive a sentence of life without any eligibility.
When the defense attorney took the floor, they appealed for compassion toward their clients, urging the court to consider mitigating factors like the brothers' upbringing, their surroundings, and the possibility of rehabilitation. The defense worked to portray the defendants as individuals shaped by their circumstances, supporting a perspective that emphasized reform and second chances over strict punishment.
Thank you, Judge. I think that Mr. Baumel put it succinctly. This case is what I describe as a horrific tragedy. We anticipate that the court will impose a very lengthy lifetime sentence. And as such, Attorney Joe Gorman and I have advised Mr. Tyus not to make a statement because he anticipates filing an appeal in this matter. And for that reason, we will remain silent and accept responsibility for this case and respectfully ask the court to appoint appellate counsel at its earliest convenience. Thank you. But I guess, I'm sorry, I would say that we concur in the merging of counts 2 and 4 with counts 1 and 3 as I think by law they should merge. Thank you.
Thank you very much, Your Honor. We're in agreement that counts 2 and counts 4 are allied offenses to counts 1 and 3, that they would merge for purposes of sentencing. With regard to, at this time, Dylann Tyus, we have advised him not to make any statement. He obviously will be pursuing an appeal. We will get to at the appropriate time to ask that the court appoint appellate counsel to find that they were indigent. I will advise the court that they will be filing a financial, or I will be filing on their behalf, or my client's behalf, a financial disclosure and an affidavit indicating that he at this time is indigent. Other than that being said, Your Honor, I know how serious the facts were in this case. We would surely ask the court to consider an appropriate sentence and possibly the opportunity that someday for Danye Tyus and Orlando, speaking on his behalf too, Orlando Tyus, the possibility that they may be at some point released from prison and have at least an opportunity at some type of redemption.
All right, and just for the record, I'm going to ask you, I understand why you may not because you're planning to appeal, but just for the record, I do have to ask you, is there anything you would like to say pursuant to your sentencing, Mr. Orlando Tyus? And Mr. Danye Tyus, is there anything you would like to say? Which would be the aggravated murder of Bon Rassavong, and there's a gun specification on count 3, which is the aggravated murder of Robert McCall with the gun specification, count 5, which is the felonious assault charge regarding Con Rassavong, and count 6, the felonious assault charge regarding Christina Heppy. Count 7 would be a weapon under disability charge relating to Danye Tyus only, and count 8 is a weapon under disability charge relating to Orlando Tyus only. The state having elected to proceed with counts 1 and 3, the court will not be sentencing on counts 2 or 4, finding that they do merge as a matter of law. I'm going to first give you some instructions, things I have to tell you as a part of the sentencing process. As to the felonious assault charges, if you serve your entire sentence and are about to be released, the Ohio Department of Corrections would be required to place you on mandatory 3 years of post-release control. As to the felonious assault charges, as to the weapon of disability charges, they would have the option of placing you on post-release control for a period of up to 3 years. If during that period of time on post-release control you were to get into trouble or violate the rules, you could be sanctioned. Those sanctions could be in up to 9-month increments, but they could not exceed more than half of your original sentence. Obviously, post-release control does not relate to offenses that involve potential parole. However, if you are on post-release control and you were to pick up a new felony, these are all things I'm required to tell you, that in that new charge, the sentencing judge could actually terminate your post-release control, give you an additional year of prison time on top of whatever other sentence he or she would give, or they could give you the remainder of your post-release control, whichever amount was greater. I also want to tell you about your appeal rights. I'm sure your lawyers have gone over those with you. The jury has found you guilty of all charges. You do have the right to appeal your conviction and your sentence. Assuming that you're indigent, the court will be appointing a lawyer for you. It's my understanding you do both wish to appeal. Is that correct? So I will appoint a lawyer for you. I will tell you that that lawyer will ensure that a notice of appeal is filed for you within 30 days of the filing of this journal entry, and a transcript of the trial will be provided at no cost to you. I also want to talk a little bit about your community control violations. So I don't normally refer to defendants by their first name, but because you both have the same last name, I'm going to refer to you by your first names, if that's okay. So Orlando, you have an aggravated possession of drugs charge for which you were on probation in another court. That judge transferred that here so we could handle this simultaneously. Based on the evidence presented at the trial, the court is, and the fact that you've now been convicted of these charges, the court is going to find you guilty of violating your community control in that case. I believe that judge had held a 1-year sentence in reserve, but in the interest of, I guess, being consistent, I'm going to impose a 6-month sentence on that, and I will run that consecutive to any other sentence that I impose in this case. And then Danye Tyus, you also had a community control violation, and I believe that was also for an aggravated possession of drugs charge. I'm just going to double check.
The judge presiding over the case carefully considered the arguments from both the prosecution and the defense. They analyzed the severity of the crime, reviewed the evidence, and evaluated the defendant's actions. Before announcing the sentence, the judge addressed those present in the courtroom, emphasizing the seriousness of the case and highlighting the justice system's duty to uphold accountability and fairness.
And then, in addition, the court is going to make some findings regarding consecutive sentences. So, in this case, there were 2 individuals who died and 2 individuals who were the subject of attempted felonious assault felonious assaults that were an attempt to kill. And so 4 different victims. The court finds in this situation, in particular as to the felonious assault charges and the weapon or disability charges, the consecutive sentences are necessary to protect the public from future crime, to punish the offender. And as to each of you, your history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. And just a little bit for the record, because I made that finding, I am going to state I'm not going over anything, but I do have your prior records here with me as adults. In particular, Danya, I believe you were living in Michigan for a while. You had some assault charges. You also had some weapons charges. You've had an assault charge since you came back to Akron. And in particular, you've had a robbery conviction in 2012 for which you went to prison. You've also had some drug convictions. We already discussed one of those. And Mr. Orlando Tyus, you've had weapons charges more than once. And in fact, you had a federal weapon charge as well, and then aggravated robbery for which you were convicted and went to prison, an escape charge, and another assault charge. And then, of course, the possession of drugs for which you're currently on community control. So as I listen to the evidence in this case, I do something that I do in every trial, and that is I try to see the case from both points of view. Throughout the trial, I would talk with the prosecutor briefly and the defense and kind of get a gauge on how they were taking in the evidence, just sort of lawyer and judge talk, trying to see the case through the eyes of the victims and the state of Ohio, and also seeing the case through the eyes of the defendants and the defense attorneys. But honestly, in this case, most of the facts were not disputed. Really, the big dispute was who did this. Well, there's not much dispute as to what happened. 2 men and a woman tried to kill 4 people. They only succeeded in killing 2. What was the motive? State's not required to prove motive, but it doesn't change the fact that that's something you sit and think about and wonder, why did this happen? Why did this happen? Was it greed? Was it a financial dispute? Was it jealousy, rage, retaliation, revenge, a mental breakdown, a loss of control? No. It was none of those things. It was simply a desire to kill. I've never had a case like this. I've been a judge for 20 years and I was a prosecutor for 10 years. I've never had a case where it was a desire to kill random people. What was the relationship between the victims and the killers? Nothing. Was there a connection that could lead to a motive? No. And the question for the family, why? Why did you kill my loved one? So as I'm sitting around here thinking of what word I would use to describe this, Mr. Baumel used the word monstrous, seems apt. I was thinking of the word senseless. So I actually looked up the word senseless, and some of the words they listed as synonyms were absurd, illogical, irrational. And those words did not seem to appropriately describe these acts. So then I looked up some other words. Cruel, cold-blooded. And those synonyms are brutal, callous, hateful, heartless, merciless, remorseless, ruthless, sadistic, wicked, evil. And those words fit. Orlando, you've been convicted of walking up to Bon Rassavant, by all accounts, a well-loved, friendly, kind of a jokester, the jester of the family, father, loved one, cousin. He was just spending time with his family because they had a sick loved one. Everyone came into town so they could talk about it and pray for their sick family member. And you walked up to him and shot him multiple times. Danya, you walked up to Robert McCall, who was minding his own business, having his own issues, but well liked by those who knew him. You actually recognized him from a previous encounter in prison. You shook his hand, and then you shot him in the eye. He had gunpowder residue in his eye because the last thing he saw on this earth was the barrel of your gun. How does one explain the darkness in the hearts of men that committed acts such as these?
In the end, justice was served. Orlando and Doña Tayus received sentences that reflected the severity of their actions and the devastating impact of their crimes. Their deeds, which caused intense pain and heartbreak, proved the consequences of such choices. The court's decision was intended not only to hold them accountable, but also to send a clear message to prevent similar tragedies in the future.
So these actions have brought you where you stand today, and I wonder if on that night you ever contemplated how this might all end up. You acted together in everything, and so your sentences will be the same. You're going to pay the cost of this prosecution. Because I find that you're going to be indigent, I won't allow it to be collected at a rate greater than $5 a month, so you can work for a very extremely menial wage while you're in prison. And the state will get its recompense on the costs, and you'll have a little bit left over. Obviously, I've designated you violent offenders. And now I'm going to go backwards. So as to count 8, the weapon of disability charge that relates to Orlando, I will sentence you to the maximum sentence of 3 years. And as to Danye in count 7, a weapon of disability charge, I will sentence you to the maximum sentence of 3 years. As to the felonious assault of Christina Heppy in count 6, I will impose as to each of you an 8-year sentence, which is the maximum. And as to the felonious assault of Khan Rasavong, as to each of you, I will impose an 8-year sentence, which is the maximum. All of those sentences will run consecutive to each other. And then as to count 1 and count 3, I am sentencing each of you to life without parole. You will get 3 years mandatory time on each gun specification. You will be confined to a dark, cold cell. You will be surrounded by others who are facing the consequences of their fateful bad choices.
On July 29, 2019, Orlando Tayus and Doña Tayus were handed life sentences without the possibility of parole for their involvement in the murders of Bon Rasavong and Robert McCall. During the sentencing, Summit County Common Pleas Court Judge Allison McCarty delivered a powerful statement to the brothers. You will never walk as free men again. You will die in prison. Meanwhile, their accomplice, Cheyenne James, who played a role in the events, pleaded guilty to felonious assault and received a sentence of 4.5 years in prison. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.